Oh, hi everyone. Welcome to episode 31. I am so loving all of the interaction and comments that you gave me on episode 30. I hope that going back and reviewing a little bit from the beginning to where we are now has helped a little bit. And then I did just a little supplementary video kind of showing how I create my stories, the work that goes into it, and showing that oftentimes our laws that we're referring to in our courts today were written for years ago, as we see in this case more specifically. We're talking about a statute that was in 1972 that's probably going to be reevaluated. And that's where I really have seen that I think that here in this little backwards town in the Midwest, we could have a landmark decision in what is and is not protected, because the only defense that her side has came up with is citing that 1972 statute with Cervantes. And I need to, I don't know, I like the way that Amber broke it down in showing how their argument is not foolproof, because that's something that before anything is actually ever brought to the point of a full lawsuit, so much goes on. So much, it's like panning gold. And it's like, okay, is this going to hold up? Is this going to, as it sifts and sorts, is this going to be strong enough? So you know that they have went back and looked at reasonable arguments and whether or not they can handle those arguments on both sides. And as we've looked at, the previous lawsuits filed against Katie Joy have all played their part into bringing us now to this culmination, to the one open lawsuit, which is 7M, which, as I noted in yesterday's video, and maybe that's more helpful because it seems like there's a lot of crosstalk in, the LA case and that. And I was confused as well until I went in and delved into this for myself, because I was thinking about what a juxtaposition it will be that this little courthouse in the sticks is going to have these big LA types coming in. And I was thinking of this succession of black Suburbans with shaded windows, and you wouldn't know which one of them had the big 7M lawyers in it, and they would all come out and have bodyguards and whatnot, because that's the way that I was thinking it was. Then, as I went in and checked it out myself, I saw that 7M has wisely chosen a local attorney. There are things that are specific in each state that are a little bit different than other states, and Minnesota in particular has some very different statutes, especially in the area of harassments, restraining orders, etc., where I've explained that it's different than anything that I saw on the West Coast. So it was a wise decision of them to hire somebody who understands Minnesota law, because you need to go where the person that you are accusing of is doing the problematic behavior. You have to sue them in their state, as we saw. And like I say, I have great confusion over the Tati lawsuit as to why it was not filed here. And I will go and find those answers myself, as I'm just focusing on the 7M one right now. And as I said, maybe it helps to call it the LA trial. And as I stated yesterday and clarified now, I see where there's some confusion. But we have to look at this as this is a civil suit right now, that for whatever reason, they only filed in civil court. So this is a civil suit. Now, in Amber's 7M lawyer, Amber Stavig, in Amber's last complaint, she did finally take the step of saying to the judge in her complaint that if the other side does not come to where they need to be here and reach these, that they are essentially, I'm going to paraphrase here, well, I'm going to interject something because I'm going to say that they could feasibly be in contempt of court, and that's where Amber took the step to say that they could face criminal or civil sanctions. That's the first time that I have seen the word criminal come into play here, as it was purely civil to this point. Now, laws are different in civil than they are in criminal. And as we know, there is one statute here in Minnesota, but that's not the statute that they cited. They've went civil here. So we're looking at civil, and that's where I went back and reviewed. And I thank you guys for going back there with me and letting me kind of go back and review. Now, where I ended on episode 30 was in the middle of the interrogatory. Let's see, where do we start? I'll show you. Hold on. I'm showing you. I just love how I just act like we're sitting here with coffee together. Because that's the way I see you all. It's just my friends. We're just sitting here having coffee and chatting. So we are still in the notice of motion and motion to compel discovery responses, which is something that will be considered in next week's hearing. We are to this point of these things are the only things being considered at this point. We've made it to this point, and these remaining and outstanding considerations are enough to continue to trial. This is what has been sifted and sorted to go, but it is still very much a civil case filed in civil court. And this is by Amber. And as we left off in this, we went all the way here. So we ended here with 30, and we're beginning part 31 on request 20. And that's where Amber Stavig is speaking or writing. We're listening to her litigating here. And so we go to request 20 here in part 31. Where it states, plaintiffs requested defendants produce all contracts they currently have with any production companies. Defendants objected as overly broad, seeks material not relevant to this lawsuit, and information subject to confidentiality clauses. A lot can be read into this because if it's referring to something that is in a confidentiality clause, what are they referring to that holds that confidentiality clause? It says plaintiff's rationale for this request is the same as that in request 19. Request 21 says plaintiffs requested all communications regarding the production of an HBO documentary regarding plaintiffs. Defendants objected due to journalistic privilege. Now, in episode 30, I laid out my opinions in that it is almost naive to consider that everything hinges upon whether or not Katie Joy is certified as a journalist. Please listen to episode 30 ad nauseum. Because I went over that so much. I don't think I can say anything more about, so what if she is considered a journalist? I mean, I'm just putting it out there. Okay, let's play devil's advocate. Let's say that, okay, she's certified as a journalist. So the point is moot. What does that have to do with anything? That she's still facing how many counts of defamation, disparagement. Go back to episode 30 if you haven't listened to it, and just because, I don't want to say too much more about it. I think that perhaps it is her narrative to say that to people, that she's like, you know what, if I'm certified as a journalist, I can do what I want. And that, is, it fits into that um little girl attitude that we see in her, where she's very flippant and myopic. And I don't know that she's able to see that there's a bigger picture here. I don't know if her mind really is that black and white, and that she thinks that, you know what, they can't do anything because and maybe that helps her sleep at night. I don't know, because if I had this coming at me, I don't think I'd sleep at night. I'd say that she has a poker face, but I think it's Botox. Oh, spilling the tea so early in this episode. Anywho, as you can see, my things have changed a little bit. As we say, that's actually what I look like. So if you want to wonder what I look like, that's me. That's my favorite outfit, especially the hat. We've got all this going on. We've got my little crystal ball there going. So you know that's the arena here. And I'll kind of let you see some things in case you're bored with seeing how I don't have this set up enough. Let's see here. Oh, see, that's me. There I am. Life size. I love that come in for a bite one. I get a lot of compliments from you guys about that too. So you see where I'm coming from, and I'd love to see your guys' space too. I know a couple of you have sent me pictures of your Halloween decor, and I freaking love it. I love every bit of it. Thank you for sharing that with me so that I can kind of think of that while I'm talking and being like, you know what, we are just friends having coffee here, discussing this topic at hand. So it may be that her attorneys can't get past that with her, and they are saying, okay, because we have to understand that, okay, well, she is paying them by the hour. It's their license that's at stake here, and they don't want a loss on their record either. So you just don't really know what they're thinking in putting this defense to their name, because we see it there. And maybe that's part of the strategy, is to just act like it's all hinged upon this and play the game that, oh, I don't know what certain words mean. I don't know. I don't know what affiliates mean. I don't know, because if it's journalistic privilege, okay, come on, it's not. Anyway, I digress. And we'll go back to the script here. As it says, as previously outlined, defendants are not journalists. Oh, whoa, 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 whoa. Whoa, 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 whoa. Okay, so here we go back and forth. So, as we know, it goes back and forth that maybe someone somewhere said this, that she was a journalist. I don't know. Maybe it happened. I don't know. But for right here, check this out. Because Amber at least is saying this. So, defendants objected due to journalistic privilege. So, Katie Joy's attorney said, you know what? That's journalistic privilege. And Amber says, as previously outlined, defendants are not journalists. Okay. So, do we get it right here? And to look at the two sides, where, okay, this is where it is. Okay. Well, if this goes to trial, what? This is going to be the first 2 hours of a week-long trial? I mean, this is one consideration. So, okay, if everybody wants to rubber stamp her as a journalist to just get this conversation out of here, then we go, okay, so what if she was a journalist? What kind of a journalist goes and says that they're taking people down and goes out on a vengeance for personal gain? For a vendetta against all religions because she's mad at God because she doesn't like the way her life turned out? I don't know. It makes sense to me. I'd shape up. But anyway, not me. Okay, so we've got these two. So now we know the defendants are there, and the attorney for the plaintiff says defendants are not journalists, and they're saying she is a journalist. Okay, well then fine. We'll just say, let's make a decision so we can move past this in my imaginary courtroom right here. And let's say that Witchy Poo rules. Okay. Witchy Poo is going to say, because if I was a judge, I would actually have a broom, not a gavel, because, I'm a witch. So we'd say, okay, with the magic broom, Katie Joy is a journalist. Boom, boom. Broom goes back for a ride back home, and the day is over. Okay. Because didn't Katie Joy say that she had always wanted to be a journalist? And that she couldn't be a journalist because all of her dreams were taken away from her because she has a child who's medically complex. Well, ma'am, so do I, and I have 6 kids and 2 bachelor's degrees and halfway through a master's program, and let's not even talk about the rest. Now what? You can be anything you want to be, and to use your kids as a reason for not being able to is not a fair assignment to give a child. That's not their a child should not bear the brunt of you not doing what you want to do. You can do anything you want to do, and you should be able to show your kids that. And let's not forget that I was pregnant my entire junior year, so I was a teen mom too. So graduated with a 1-year-old, and so I'm not fond of some of the things that, have been said about teen moms and all that stuff. I just kind of roll with the punches and be like, so teen moms are dumb, huh? Oh, okay. All right. All right, anyway. And that was in 1989. I had my baby in 1989. So anyway, we go here. And we say, as previously outlined, defendants are not journalists, and this information is not protected by a purported journalist's privilege. Further, the journalistic privilege in both Minnesota Statute 595 and Cervantes only extend as a one-way protection of journalists revealing their own sources. Exactly. They do not allow persons providing information to a documentary company from... They do not allow persons providing information to a documentary company from disclosure. Okay, that sentence is not okay. They do not allow persons providing information to a documentary from disclosure. Okay, it should be something like prohibit, because let's play this out. HBO isn't going to say, oh, yeah, we have this person and they're saying that. Well, yeah, they have sources. Oh, HBO is going to say, excuse me, who's your sources? Yeah, let me have their number, and we're going to go to them. And we're going to ask them exactly how they came up to this. And you're going to say, well, I can't give them up. And they're going to be like, yeah, okay, well, thank you for your participation thus far. Click. And they're never going to call you again. Everybody's going to vet what part goes into everything, because this would have to go through all of the parent companies' lawyers to make sure that then they are not going to get in this kind of trouble for their documentary. Anywho, they do not allow persons providing information to a documentary company from disclosure. Like I said, that sentence doesn't make sense. And then it says, as defendants have given information to HBO or its affiliates for the purposes of creating a documentary, it is assumed that contract had some sort of monetary consideration to defendants. Okay. What? Okay, I see. Defendants are potentially gaining monetarily from this documentary, which goes to defendants' motive in posting about plaintiffs. Okay, I can see that, because they're saying, okay, you're posting so that then you get a position in this documentary, because that's your freaking dream, is to get onto a documentary that's on HBO. Okay, I can see that. I can see that would go to motive. We all agree? We all agree. Yeah. I'm trying to think of an argument to that, but no, I see it. I see it. And then it says further, the conversations and correspondence given to defendants to the documentary are extremely relevant, as plaintiffs are entitled to review the nexus of information between what defendants were told from their sources to what they stated on their social media platforms, as well as plaintiffs' claims rest on defendants creating false information and stories about plaintiffs. Information which proves that it is both discoverable and relevant. The extent of which defendants spread false and defamatory information is not only relevant to, but the entire point of this lawsuit. Boom. As such, defendants are required to answer this request. Bam. Request 23. Plaintiffs requested all communications regarding the production of a Netflix documentary regarding plaintiffs. Defendants objected due to journalistic privilege. Copy paste. Plaintiff's rationale is the same as that in request 21. Okay, stated the same. Confused? See, aforementioned. Request 24. Plaintiffs requested all contracts regarding the production of a Netflix documentary regarding plaintiffs. Defendants objected due to journalistic privilege. Remember that day when we were saying objection? Now, this is here, more objection. Plaintiff's rationale is the same of that in request 21. Okay, so we're going back to that, And is this repetitive? It is so repetitive. Okay, so now we go over here to interrogatories. Interrogatory number 2. Plaintiffs requested defendants identify each person they are aware of who may have knowledge of or who is likely to have knowledge of discoverable information relevant to the facts and circumstances of the claims in this lawsuit. Defendants objected on the basis of journalistic privilege pursuant to Minnesota Statute 595.021, TAC 025, and Cervantes versus Time Incorporated. And again, this is why it's valuable to have a Minnesota attorney understanding Minnesota law to another Minnesota attorney trying to defend. And I put this star here because when I was just trying to leaf through to see if I could see ahead or see anything in between, whereas this discussion was up in the air everywhere last week in discussion forums that, Katie Joy had been certified as a journalist or with a judge or whatever. I was trying to see where that came from. And I don't see it as a date, as a time, what judge, etc. And I told you we had a broken judge and big problems, and so there's a whole upheaval in our whole county, and a new prosecutor, a new judge, a new courthouse, and now there's even paved roads going everywhere to the courthouse. They're not all the way open yet because they're going to make a big old intersection instead of that two-way lane that was going down from the dirt road. It's all paved and nice. It'll be all nice and pretty for you. A new jail for everything. New workhouse. That's real nice. Well, anyway, we go over here. And we say, see prior discussion regarding defendant's purported journalistic privilege. So as I went and peeked, all I was missing was over here on the other page. It was just right above. And it says defendants are required to identify individuals who may have discoverable information relevant to this lawsuit. That's a fact. Interrogatory number 6. Plaintiffs requested all facts which support each denial in defendant's answer. Defendants objected on the basis of interrogatory attempts which expand the number of interrogatories. Defendants have posted no law to support that as a valid objection. Further, the answer to this interrogatory could be the same if we asked for a specific denial or for all of them. Defendants must answer reasonable discovery requests pursuant to the rules of civil procedure. Requesting identification of facts which support the denials in defendant's lawsuit is the most basic principle of the discovery process. The basis of this lawsuit is that defendants made up lies about plaintiffs and it caused them harm. Requesting discovery to show defendants' claim that they did not make up the statements they made about defendants is the most relevant part of this lawsuit. Defendants must answer this interrogatory. She doesn't get to just slither out of this and say, journalistic privilege, don't. No, it doesn't work that way. And if it, I mean, I don't know. Give us a little crystal ball there. Okay. Interrogatory 7. Plaintiffs requested each statement defendants have made about a person, entity, organization, etc., for which defendants did not have verification of facts from the person or entity whom the statement was made about from January 2020 to the present. Defendants objected to this interrogatory as overly broad and unduly burdensome. Plaintiffs provided a specific time period for which defendants need to provide instances where they shared information about third parties, including but not limited to the plaintiffs. Defendants have been the subject of numerous lawsuits for false and unverified statements about third parties. The total amount and frequency of the statements for which defendants have made false or unverified statements is highly relevant to this lawsuit. If this interrogatory is overly broad and unduly burdensome, it is only because defendants have a regular habit of making false and unverified statements of fact. Defendants are required to answer this interrogatory. And this is where, like, when I was talking about what happened in the hearing, the first hearing where the attorneys saw each other face to face, yeah, and that remains the only one where they've seen each other face to face. And that's where, Jennifer Moore said, I have a client who posts daily, if not several times daily, and it's hard to keep up. She was overwhelmed. An attorney should not have to say that. To have a client behave in that manner is unusual. Let's just say that. I mean, can you... I better shut up. Interrogatory number 9. Plaintiffs requested the number of followers purchased by defendants from January 2020 to the present. Defendants objected. Relevance. This lawsuit is based on defendants' false and defamatory statements and dissemination to their followers. Defendants have claimed that they are a journalist instead of a social media personality. Purchased followers are relevant to defendants' claimed status as a journalist, as well as to the extent of the dissemination of her false and defamatory statements about plaintiffs. Defendants are required to answer this interrogatory. Interrogatory 11. Plaintiffs requested defendants provide the name, address, and contact number of each person who provided defendants with information regarding plaintiffs. Defendants objected as protected by journalistic privilege and stated where relevant sources were named in posts. See prior discussion regarding defendants' purported journalistic privilege. As previously stated, defendants have deleted or may have edited their social media posts. Further, defendants have failed to provide a legal basis for stating they are named in the posts. Where plaintiffs requested the name, address, and contact number of each person who provided information. Defendants have no way to contact a person for this lawsuit if they were named in a since deleted post. Defendants are required to respond to this interrogatory. Interrogatory 12. Plaintiffs requested defendants provide the name, address, and contact number of each person to whom defendants provided information regarding plaintiffs. Defendants objected as protected by journalistic privilege. See prior discussion regarding defendants' purported journalistic privilege. As previously stated, the journalistic privilege claim does not protect defendants providing information to third parties. Defendants are required to answer this interrogatory. Interrogatory 14. Plaintiffs requested information regarding Melanie Kelly and Dean Wilking. Defendants objected on the grounds that they are not parties to this lawsuit and therefore that information is not relevant. See plaintiffs' prior discussion of the relevance of Melanie, well, look at they spelled it wrong, Wilking, the G is in front of the N there, and information relating to non-parties. Defendants' initial posting about plaintiffs included numerous references to her communications with the Wilkings. Now, I'm going to go off script here for a second. This is the only part where I feel is problematic. And they may have to let this part go. It would be, and maybe they know that it's, maybe 7M knows that it's a weak argument and it's something that they have as a bargaining chip to let go, but they thought that they would see if it stuck. I don't know. Now, one of the things that I wanted to mention is that when I did my little 12-minute thing and I was showing how I reference certain books and I talk about them and scraps of paper, showing how when it says not to destroy documents and to show your rough drafts, they're talking more about people like me in the way that the world was, where you would have your rough drafts, your little scribblings, your diagrams, maybe marking up a book, etc., etc. So as the world is digital and there's digital creators, then it could be said that, oh, my computer crashed and I don't have this, or don't have this in the cloud. I see where it could be harder, but I also think that there's a sense of personal responsibility, because even I know, because I'm a younger creator, been in this for a year and a half, but as I saw other channels coming down for this or that, and it was ever changing in YouTube as to what was and was not acceptable. One of the main channels I saw was Plunder being taken down, and it was because they were saying that she's not real or whatever, that basically she's just repeating news things, whatever. So Plunder had to show how she created things and how she came up and where she procured her information and whatnot. And she did a great job and fought and got her channel back. So that was a huge lesson to me, to remember to keep everything and keep good and copious details as to what I'm doing, how I'm coming about this information, where this information stemmed from, where I heard it, what channel, and then where did I go to look and see, did I, because sometimes I'd have to go to opposing channels to hear both sides and then go and find the truth somewhere in between. So I showed in this little video that I did, that's just 12 minutes, that you might want to see. I showed how if I were to say something about the Mormon church, I would refer to, I have Mormon books because I have a lot of Mormon friends, and grew up in a community that's strong with Mormons, and I have a lot of Mormon friends that I really respect. And with any religion, there are the extremes, and the problematic Mormons are in the minority, and they're in the extreme fundamentalist group of Mormons, and then there are mainstream Mormons. So I had just used that as an example of showing. And so it's kind of ironic because I recorded it and it hadn't went live yet. And before I came on, I saw that Llama Girl just posted a post that Katie Joy had done. And it shows where Katie Joy says she's taken down the Mormon church. It's like, what? And I can't tell if she's being facetious, like, oh, I'm accused of this, or now she's going for it. And it's like, oh my God, do not take on the Mormon church. It may help here, seeing that she says those things, because she includes the religion of the people that she's talking about as a whole, because she wants to purport that she's this atheist. And if you guys saw the post about the dog eating the Bible, and I've talked about how I don't believe that. I've for all the Bibles that are in houses, I've never once seen an animal eat a Bible. I mean, even animals know better than to, be sacrilegious. And I kind of feel like, what, did she just have a big fit and she tore up a Bible and then made a funny post about it and said the dog did it? Like, the dog ate my homework, we joked about that. But her continuing to post things like that, I would imagine, would upset her attorneys. Because right now, while she's got big eyes looking at her, she needs to be careful. And I'm sure they've told her that, and she doesn't care. So it's not like I'm giving any answers away. Don't be like, oh my God, don't tell her this. She'll do whatever she wants. We see that she's very, 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 very much like a stunted teenager, doing whatever they want, no matter what anybody tells them. And to take on whole religions, like how she's with Robert Shin, and she accuses the Shekinah Church of being this and that. And okay, if she wants to say that, talk about who came forward and told her these things. If you have to do it behind closed chambers with a judge and your attorney, you do it. You don't just say, oh, yep, journalistic privilege. No, because if you are saying such things that are costing people money and, as she has said, human trafficking, etc., waterboarding, those are criminal actions. So if criminal behavior is going unchecked, that needs to be evaluated. There is so much at stake here that she cannot continue to hide behind the imaginary cloak of journalistic privilege. And she just doesn't stop. She really feels she's invincible. And maybe she is. Maybe she is. And we're all just we all just are in her world and just have to watch. Who knows? Just a second. Kisses, I'm over here, honey. Kisses. Kisses. Come here, honey. Come on. Kisses. Come here. Sorry, my cat's caterwauling. She doesn't know where I'm at. Kisses. Come here. Come here. Come here. Sorry. She cries when she can't find everybody. She just, if you hear her, she's like, yeah. All the lights are off and everybody's in bed. She's like, oh, where is everybody? Kisses, come in here. She's been really cuddly lately because the weather changed and she's a little cold. So, oh God, there went one of the crystal balls. The balls fell on the floor. Okay, back to the script here. Further, defendants had a hyperlink which connected the Wilkings social media during the start of her campaign against the plaintiffs. As Ms. Paulson has clearly had significant and continued contact with the Wilkings, and it appears much of that information has been shared by Ms. Paulson with third parties, it is extremely relevant to this lawsuit and must be disclosed. I don't know. Do you think that the Wilkings will be called as witnesses? Interrogatory 15. Plaintiffs requested the name, address, and contact information of any reporters defendants shared information with as it relates to plaintiffs or any persons associated with plaintiffs. See prior discussion regarding defendants' purported journalistic privilege. If defendants provided information to a reporter, they are required to disclose that information in a lawsuit where the entire claim is that defendants engaged in a campaign of spreading false and defamatory information. As such, defendants are required to answer this interrogatory. Now, Will we get into a whole day of trial trying to figure out the difference between a reporter and a journalist? Ooh, what constitutes a reporter? What constitutes a journalist? Interrogatory 16. Plaintiffs requested the name, address, and contact information for any third parties defendants have had contact with. Regarding plaintiffs, along with a date of first contact and a summary of all matter which were discussed with that third party. Defendants objected as protected by journalistic privilege and stated the names were relevant. And stated the names were relevant. Stated the names where relevant were in the posts made. Okay, let's see here. There's just some grammar missing here, so let's break it up. Defendants objected, let's put a comma there, as protected by journalistic privilege, and stated the names where relevant were in the posts made. Maybe there's just some wrong emphasis on the wrong syllable there. See your prior discussion regarding defendants' purported journalistic privilege and full disclosure of information contained in posts within defendants' possession. Defendants must respond to this interrogatory. Interrogatory 17. Plaintiffs asked what information was provided to defendants supporting their statement 7M Films Incorporated and Robert Shin are involved in human trafficking. Defendants objected based on journalistic privilege and plaintiffs' paraphrasing words. Defendants further provided a couple of court cases and stated various social media posts published by interested parties and news articles published by other journalists. Okay. And here we go. Copy and paste. See prior discussion regarding defendants' purported journalistic privilege. Plaintiffs in their summons and complaint have alleged defendants stated Robert Shin and 7M Films Incorporated were involved in human trafficking. If this statement is a paraphrase, defendants are required to answer and state that or deny that they made such a statement. Plaintiffs did not request what court files defendants reviewed. The interrogatory asks what information was provided to defendants. Defendants are required to fully answer this interrogatory with what specific information was provided to defendants regarding plaintiffs. Defendants' answer of various social media posts published by interested parties and news articles published by other journalists is evasive and incomplete pursuant to Minnesota Rules of Civil Procedure, page 37.01, section C. Defendants are required to provide specific information in response to this interrogatory. Interrogatory 18. Plaintiffs asked what information was provided to defendants to support their statement that 7M Films is a cult. Defendants objected based on journalistic privilege. Now, I was going to say, arguably, this one might be something that can be thrown out as well, because is there always a negative connotation with being in a cult? Yes, no, maybe so. I don't know. It seems like this one could be, I mean, I would be more concerned about the human trafficking than I would the cult. But who knows? See prior discussion regarding defendants' purported journalistic privilege. Defendants are required to answer what information was provided to defendants to support their statement 7M Films is a cult. I mean, there are specific connotations to what is a cult that people, who evaluate cults go through. Interrogatories 19 through 24. Plaintiffs asked what information was provided for the following statements defendant made. 19. The worst part of this cult is that they are preying on Black dancers, exploiting them, and then making them believe everyone is mad at them because they are Black. Oh. 20. I don't want to get in trouble by YouTube by saying these things. Okay, I'm just going to make really sure that we're reading here so that it's shown that I'm not talking in this way, because we're going here saying interrogatories 19 through 24, plaintiffs asked what information was provided for the following statements defendants made. Okay, we just went through the one that's very sensitive culturally, ethnically. The next one is that Robert Shin S.A.'s women. How about if I say it like that? And you guys can see what it says there. Let me see. Put the light on it. I'm not saying this. I'm reading this, so please. I'm not saying I feel this way, or I don't know enough on the topic. So anyway, and then it says in 21 that Robert Shin is instructed by God to teach young women about S, and that he induces them into joining his cult. And then that 7M dancers are under mind control. Number 3 states that dancers are told and believe they are anointed by God. The source alleges Robert has brainwashed them to believe outsiders are not worth of their time and dangerous. There's a Y missing there because it says are not worth of their time and dangerous. So probably should be worthy, but 24 says social media managers at 7M Films Incorporated are blocking any family member and friends that try to reach out. Defendants copy and pasted the same objection based on journalistic privilege as a response to each. See prior discussion regarding defendants' purported journalistic privilege. Defendants are required to state what specific information was provided to them for each of the statements as well as the persons who provided them. Interrogatory 25. Plaintiffs requested that the information provided to defendants which supports their statements that leaders threatened to their families if they kept in contact with them. Again, that's a word I don't think I can say here. Defendants objected on the basis plaintiff's amended complaint did not make this allegation. Okay. There's some deep stuff here. These are very serious things to say. Plaintiff's amended complaint referenced all posts past and during the course of this lawsuit. As defendants have continued to post false and defamatory material regarding plaintiffs, all material is relevant. Okay. I think that this could be problematic because when I went back in the amended complaint, they did take out, where did I see that? They took out, I think, they removed here from 227 through 3:1. So 227 to 3:1, where these things are in the original complaint, when I was reviewing it, I saw that they are indeed not included in the next one. And so, as we can see, these ones are there. But is it right for them to say, well, you didn't include it in the next one, so we don't have to answer it? And I don't know. I mean, they're not being very conciliatory. They're not showing that they are making an effort to get to a point where they can agree and go their separate ways. I see that as also flippant, but that's just me. And it says that As defendants have continued to post false and defamatory material regarding plaintiffs, all material is relevant. If defendants claim that they did not make the statement, they may state they did not make such a statement. However, as the interrogatory asks a question about a statement defendants made about plaintiffs, it is relevant to this lawsuit, and defendants must answer the interrogatory. Interrogatories 26 through 40 says, plaintiffs asked what information was provided for the following statements defendants made. 26 says, 7M Films Incorporated dancers are not allowed to answer questions and that everything must go through Hannah Shin. And then it says, your pastor, and it says, Robelli Shin. Now look at this. Now when we saw this, it was put in quotes, and we see that pastor is misspelled. Okay? It is repeatedly misspelled and is in quotations. So I would assume that they're saying that that's the way that Katie Joy wrote it. Now, where we see this right here, Robelli 1 Shin, we can see that that's a typo, and that's coming from Amber's side. So as you see this here, your pastor, Robelli Shin, we've got errors all around, and you know how I just tisk to that. But anywho, has been accused of spying on members, placing, and they're saying this about Robert Shin, or Robelli Shin, that's the way it's stated, has been accused of spying on members, placing spy technology on computers, hacking and monitoring all electronic communication of members. And then it says Robert Shin's church is forcing dancers to live in properties owned by them in dangerous neighborhoods. How? That's just, I don't even know. I mean, any neighborhood can become dangerous. It's not, I don't know. Especially in California. I mean, there's bars on windows for a reason, but rent is so expensive. Anyway. Church members are not allowed to own or drive their own cars, that the most committed members hand over their financial lives to Hannah Shin. And there's 2 N's in Shin, and there's only 1 here. So I don't know if they're taking things directly from her posts or how we're doing that. And it says she pays bills, taxes, and makes sure the tithing church gifts are all made. And then this is not capitalized. So again, I don't know if they're just, putting things exactly as she wrote it, or if somebody was asleep at the wheel while they're writing this right here, because there's a lot of errors. Anyway, it says, as alleged by other church members, Shekinah leadership has access to bank accounts. And it says Miranda Derrick missed a family funeral due to 7M Incorporated statements that they would not pay her if she went. And then it says dancers' lives are so tightly controlled that they can't do anything without... Look at this. Look at this. That's supposed to be a K, but it's a Fielding. Doesn't anybody proofread? That would have came up in spell check too. I mean, some of these things wouldn't have came up in spell check so you can see it, but this is bad. I better shut up. I better shut up. All right. So that's supposed to be speaking to Daniel first. And it says, if Daniel says no, dancers can't do it. And then it says 7M is not only trying to control the dancers, they also want to control the government. And then it says here that 34, B-Dash was a victim of the Shins and that he was also used to lure Miranda in with a question mark. And then it says 7M Films psychologically abuses its dancers. And then it starts here, and this is not capitalized, of course, where it says physical appearance and diet are important to Robert Shin. And then we go again here on 37, where it's misspelled. It says your pastor, and then we have Robert Shin here, spelled correctly, has openly admitted that he curses people that do not donate to him with a question mark. And then it says in here in quotes, it says Robert waterboarded Dom. So maybe this is the way that she wrote it all, and they are quoting exactly, or I don't know. And then it says, Robert Shin is using the church to defraud people and enrich himself by funneling donations to shell-for-profit companies. And then it says that the Clippers are cutting ties with 7M with a question mark. And then it says defendants copy and pasted the same objection paste on journalistic privilege as a response to each. They did. You can tell they did. And then it says, see prior discussion regarding defendants' purported journalistic privilege. Oh my God, journalistic privilege. My God, they just do need to rule either or and go past this. It's so redundant, myopic. Ugh. Defendants are required to state what specific information was provided to them for each of these statements, as well as the person who provided them. Again. Interrogatory 45. Plaintiffs requested the reasons for each of the defendants' affirmative defenses. Defendant objected on the basis that it is a legal conclusion. Okay. And then we head over here, and it said this is not a valid objection to an interrogatory pursuant to Minnesota Rules of Civil Procedure 33.02. An interrogatory otherwise proper is not necessarily objectionable merely because its answer involves an opinion or contention that it relates to fact or the application of law to fact. This question asks defendants to explain their reasoning for their affirmative defenses using application of law to fact. As such, defendants must answer this interrogatory. Interrogatory 46. Plaintiffs asked for the factual basis and reasoning for defendants' denials in their request for admission. Defendants objected on the grounds this would expand the number of interrogatories. Defendants have failed to provide a legal basis for this objection. Further, plaintiffs have not used all of their interrogatories, and therefore an expansion may be proper. Defendants must answer this interrogatory. And the conclusion states, defendants have failed to provide relevant and discoverable information requested by plaintiffs pursuant to Minnesota Rules of Civil Procedure, page 33 and 34. Further, they have failed to outline a legitimate legal reasoning for their failures to respond. As such, plaintiffs' Rule 37 motion to compel full responses to discovery must be granted, and costs, disbursements, and attorney's fees shall be granted to plaintiffs for their costs in bringing this motion to compel. And this is signed by Xena Warrior Princess, aka Amber J. Stavig, attorney for the plaintiffs. And this was dated there in that July 11th, 2023 time period. So, well, this was still under review. Remember, everything was pretty much frozen in time so that Katie Joy's attorneys could try to catch up. And then they were given that, 6-week period of time to be able to speak by phone to confirm or deny that indeed they were caught up. And we can assume that they were caught up and that they went ahead and told the judge that they could put in a template timeline for trial, which Amber Stavig had stated that reasonably a trial would be a year out, and that was back in this July timeframe. So we're going to get right to where they are, because then 32 is going to begin with the notice of motion and motion to compel discovery responses, and we just got a little bit more. So we will get there so that we will know exactly what is at stake here in the hearing scheduled for next week, which I am still trying to be able to go to, and I've not had any luck in being able to find a way to go yet, but I'm still working it. So we'll see. If I don't go, I don't think I'm missing too much. But anyway, that is episode 31. I thank you all for listening and supporting me and hear from my exact likeness. I will say goodbye to you, and I will see you in episode 32. I love interacting with you, and I love the food for thought and the conversation that you give back to me as we're all sitting here as friends having coffee. Thank you for your time. Your time means more to me than you know. I appreciate your time, and you are all valuable to me. Thank you so much for all the support and love that you give to me. It means more than you know. So thank you, and I will talk to you later. Bye bye now.